Next case on the docket is Kenneth McIntosh versus the DEVEREUX Foundation.
If it pleases the court, Your Honors. Good morning. My name is Hubert Brown. I'm an attorney with Brown & Brown Attorneys at Law, PA in Tallahassee, Florida, and represent Mr. Kenneth McIntosh in his individual capacity. I also have my co-counsel, Thomas Brown, here with us today. I would like to reserve 4 minutes for rebuttal with the court's permission. There's a well-known saying among parents that they will give their lives to protect their child. However, there is no similar saying that a parent would give his life or even incur injury to protect a corpse of a loved one or to protect a dog. That's because the level of care and loving that a parent has for his child goes much stronger and much deeper than that care for a corpse. And in fact, as the court might know, funerals now are not really called funerals, they're called homegoing services. There's been a change in the way that people look at death nowadays. There's not as much crying at funerals. There's more of a homegoing celebration. But the reason we're here today is that Kenneth McIntosh has a daughter named Pinky McIntosh that was born on April 15th, 1979. And she is a mildly mentally retarded young lady. And in May of 1995, when she was approximately 16 years old, she was sent to DEVEREUX Foundation in Viera, Florida. Prior to that time, without Mr. McIntosh's knowledge, there was a guy named LeVar Burke who was also brought from New Jersey all the way down to Florida to stay at DEVEREUX. And
let me stop it for a second, because I think we're all pretty familiar with the facts.
Yes, sir.
If we accept your argument, does that mean in a typical sexual battery case where a woman is the victim, let's say, of a sexual battery, regardless of her age, 15, 20, 25, that upon hearing the news that any other close family member, spouse, child, parent, sibling could bring an action for emotional distress against the offender?
Well, Your Honor, in this case, it's dealing with not the offender, but the corporation that brought this offender down there, who was a sexual predator. And no, Your Honor, it would not apply in those cases against others who committed simple negligence. But in this case...
Well, I'm talking about the offender. Using this example, would you agree that if your client can bring this action against DEVEREUX, it could also bring it against the Mr. Burke?
Your Honor, I would agree that they could. And citing the case of this here court in the city of Manila, that one could be limited to the parent, spouse, sibling, that they could. And Your Honor, there would not be a floodgate running to the court, because more than likely, these offenders are not someone with money that one could sue and get big judgments. So there is a limit just from economics. It's not going to flood the court with a lot of cases. But also, Your Honor, there is something very special about someone being violated by rape and by these sexual predators. In fact, the Florida...
Yes, if we were to accept your position and extend liability where it really hasn't been extended, I think you would agree that this would be an extension of liability beyond any recognized currently under Florida law, correct?
If we draw it narrowly, Your Honor, we would. But
and we would have to conflict with MM versus MPS out of the third DCA, correct?
Your Honor, this court has already distinguished that case in the city of Manila. They distinguished MM because that is very different than a case where a child was actually in Ford Motor Company.
Well, the Williams case, city of Mineola, the court very clearly said in that case we're carving out a narrow exception dealing with dead bodies. And that was the basis for their distinction. Clearly that was the basis for the distinction, correct? They did not expand the rule announced or repeated, I guess, in MM versus MPS that if the parents weren't present, since they weren't the targets, that they don't have a cause of action for intentional infliction of emotional distress. That's what they said, the third DCA said in that case, relying on one of our cases and on the restatement itself, correct?
Well, Your Honor, it did distinguish on the fact that MM was also dealing with the child and parents. But, Your Honor, it did narrowly carve it out and said there was a difference here because of corpse. But that's why...
But you're asking us to do away with the target and presence requirements altogether.
No, sir. In this limited case where someone brings in a sexual predator to a facility and violate Florida law, where Florida law says you cannot even live within 1,000 feet, and that law was in place at the time that DEVEREUX brought in Mr. LeVar Burke. It became effective October 1st, 1995. Ms. McIntosh was raped in December 1995. So in those cases where someone violates openly and notoriously the Florida law that's protecting that...
You're asking us to also extend it to any sexual battery case. Any perpetrator of any sexual battery, the parents or other family members, upon finding out about that incident, would then have an intentional infliction cause of action against the perpetrator, as well as potentially anybody else who arguably, by their conduct, put the perpetrator in a position to batter the victim, correct?
Not any other person, no, sir. Only if they committed gross and reckless conduct. If it was simple negligence, that maybe they failed to lock a door and a predator comes in and rapes someone, no, sir, that would not apply that standard to them. But only where they intentionally and recklessly cause another to be raped. And, Your Honor, as I said, in the legislature, they found that sexual offenders are extremely likely to use violence and to repeat their offenses, and most sexual offenders' crimes have many victims that go unreported. Your Honor, we will be protecting rapists, and I don't think the Florida public policy is here to try and protect a rapist from a family member who, Your Honor, if a child is raped, who are put in someone else's custody or just...
Don't you see another distinction between the dog and dead body cases that doesn't exist here? And that is, in this case, the alleged outrageous conduct is subject to civil liability because the victim herself has a cause of action for damages and for punitive damages, so a significant cause of action in terms of financial even punishment against the perpetrator of the outrageous conduct. But in the dog cases and the dead body case, if you don't allow a cause of action under this kind of theory, if you don't carve out an exception there, then you have outrageous conduct for which there would be no civil liability whatsoever, because obviously a dog can't bring cause of action, and obviously a deceased person under these circumstances for this kind of injury could not either.
Your Honor, it is very similar to the dog case because we must remember that more than just Pinky McIntosh was injured in this case. Mr. McIntosh was severely injured. There's testimony that we have from psychiatrists, and he will be left without a remedy. And one of the tenets of the Florida Supreme Court has stated that every wrong
but that's
should be a remedy.
Isn't that true of everybody who is, for lack of a better term, barred from this cause of action because they aren't a target or weren't present at the time that the incident occurred?
But there are a number of cases where people have recovered. Like I said, Your Honor, in the Ford Motor Company case where the creditor called the mother of the plaintiff, didn't even talk to the plaintiff directly, yet the plaintiff was able to recover from Ford Motor Company. So, Your Honor, it would be an anomaly to place someone suffering over a dog, over a corpse, above someone suffering over their child being raped, Your Honor. And we would argue that in this particular case, to deny Mr. McIntosh his recovery would be similar to denying the owner of a dog a recovery, because he has damages also. He has damages also for the cost of the extraordinary cost of raising his granddaughter, Tina McIntosh.
I mean, the kind of emotional argument that you're making is an argument to do away with the target and presence requirements in any case where anybody is going to be emotionally harmed.
No, sir.
That's what you're saying. If there, anytime there's a clear emotional harm, which I agree with you, there certainly is here, you should just do away with any bars to recovery that emotional distress ought to be compensated.
No, sir. If the court would like to limit it, let's limit it to rape cases where the Florida legislature has found that these are extremely egregious situations where not only, unlike other offenses where the person serves their time and then they are able to get out, in sexual predator cases, which we have alleged that he is a sexual predator and have evidence that he had violated 13-year-old and 2 other victims, minors, before this happened, that the Florida legislature has specifically carved out in these cases that one can be civically committed after they serve their time. So this is a special case.
The legislature could also create a civil remedy if they elected to, couldn't they? I mean, they haven't done that.
Your Honor, they could, but Your Honor, if we go back and look at the actual elements of intentional infliction of emotional distress, which is deliberate or reckless infliction of suffering, outrageous conduct, the conduct must have caused emotional distress, and the distress must be severe. Mr. McIntosh meets all of these here elements. So we're not necessarily carving out a new one. Those are elements designed to make sure that someone truly suffered significant and severe emotional distress, and also there has to be outrage.
Well, if you limit it to rape cases like you suggest,
Yes, sir.
let's look at what that does for causes of action against perpetrators. And I'm not persuaded by lots of perpetrators don't have money so you couldn't sue them, because there are perpetrators who you could sue.
Yes, sir.
Is it your position then in every rape case that the perpetrator could be sued not only by the victim but by any close relatives who can show that they were emotionally damaged when they learned about the rape?
Your Honor, I would not say any close relatives. The relatives that this court itself has identified, the spouse, the sibling, the parents, yes, sir, I believe so, because there is no public policy served by protecting rapists. There's no public policy served, Your Honor. And so to protect a rapist who has a high recidivism rate, we might need to show them and try to stop them. Since incarceration, the legislators have found that hasn't done it, they're hard to rehabilitate, then maybe if we can hit them in the pocketbook, that will stop some of this recidivism. So, Your Honor, in that case, not everyone, but in the people, in the class of persons that this court itself has found, yes, Your Honor.
What about murderers then?
What about murderers?
Murderers.
Your Honor, in that class of persons, yes, sir, Your Honor. The legislature, I think a murderer is as egregious as a sex offender. There hasn't been as far as the repeat findings that the legislature did for murderers, but that is most egregious. And again, there is no public policy to support and protect murderers from paying their financial costs. In fact, they already in other areas have to pay restitution criminals, so why can't they pay for their other damages?
Sounds like by your argument you could apply it to any felony.
No, sir, Your Honor. I really
What
would-
about aggravated battery? If someone beat up your child severely?
Your Honor,
To me, that would be very emotionally traumatizing to me if that happened to one of my children.
Your Honor, I would agree it will be
Aggravated battery too?
it will be traumatizing, Your Honor, but the likelihood of recidivism hasn't been established the way it has in rape cases. And so I think that is a narrow example that one could craft a remedy in this situation, in the most egregious situation, that we could still craft that remedy without opening up these floodgates, Your Honor. But, Your Honor, there is one other thing that I would like to touch on briefly, and that is, as far as Mr. McIntosh's last remaining claim was thrown out, dismissed with prejudice. Your Honor, we feel that he had a clearly obvious claim that the trial court itself says was an age-old claim, and that was loss of filial consortium. And he was not given an opportunity to amend his complaint and bring in that claim. And so, Your Honor, we would ask, considering Florida's public policy.
Am I correct that the first time that issue was raised, or the first time you asked the trial judge for leave to amend, was in a motion for rehearing that was filed one day before your notice of appeal was filed?
That is correct, Your Honor, but
what about the rule that in order to argue something on appeal, you have to timely present it to the trial judge in time to get a ruling?
Well, Your Honor, in Strader versus Carpenters, Your Honor, we didn't even need to file a motion for leave to amend because it's considered to be abuse of discretion just to dismiss a case without giving a person leave to amend unless you can establish that there was no possible way that one could amend under the facts. So that is a red herring, Your Honor, brought up by the defense that we need to file.
Now, I'm not familiar with any case in which it was held that you don't have to request leave to amend in order to argue on appeal that you were improperly denied leave to amend. Are you saying that was the holding of that case?
Your Honor, we cited a number of cases where the courts never discussed whether a leave to amend was filed or not. It was just that it was a violation of abuse of discretion to dismiss a case with prejudice.
Wouldn't you agree that appellate courts generally don't always say that an issue is preserved for appeal? They address issues that are preserved. The issues generally raised or discussed in cases where there's no preservation.
Well, Your Honor, even if we take the position that you have to file a motion of leave to amend, we did do it within the 30 days requirement. So it is properly preserved for this court because, Your Honor, the two cases cited by...
Well, but that motion was abandoned when you filed your notice of appeal the next day, right?
No, sir.
Pending motions are abandoned when you go ahead and appeal, generally.
No, sir.
Ruling on them.
We didn't abandon that because it was our position that the original order that we did appeal was an abuse of discretion and as a result preserved that error because it was not allowed giving us leave to amend at that time. That is a standard protocol that should go when there's a motion dismissed. And the case law is there's quite a bit of case law on that.
Your argument, if I correctly understand it, is they move to dismiss, the judge says dismissed with prejudice, you don't have to file a motion to amend, you've preserved your right because we can review whether or not the court abused its discretion by dismissing with prejudice rather than without prejudice. Is that right?
Yes, sir, because the standard of reviewing this is abuse of discretion. And so the court, that's a matter of law, can look to see if it was abuse of discretion. Your Honor, I'd like to reserve it with the court's permission.
Got about 3.5 minutes.
Thank you, sir.
Good morning. I'm Hinda Klein here on behalf of DEVEREUX. The trial court did not abuse its discretion. It was absolutely correct in not permitting an amendment because, as the court notes, it was never requested until the day before the notice of appeal was filed.
Does that mean that after we resolve this case and the case goes back to the trial court that they can then file a motion to amend?
No, Your Honor. Once the dismissal was entered, the case is concluded. And unless this court actually reverses that dismissal, there's no mechanism by which the court would regain jurisdiction over this case. For the record, and just for this court's notice, this case is actually going to trial on Pinky McIntosh's case 2 weeks from yesterday. I wanted the court to be aware of that, just to correct a statement in our facts that it was due to be tried approximately 2 months ago. And I did want the court to note that Pinky McIntosh's case is still in fact pending and it will be tried in about 2 weeks. So in any event, I think the court is aware that there are no cases that I was able to find, finding that it was reversible error not to permit leave to amend when it hasn't been requested. And of course there's a very good reason for that, and that is because in order to permit the amendment, one not only has to make the motion, but has to actually plead the amendment for the court's review, and of course that wasn't done here. The merits...
Let me ask you this, even assuming that there was not a preservation problem, I agree with you that there is a preservation problem. To state a filial consortium claim under Florida law, wouldn't they have to allege permanent total disability of the victim?
Correct, and that is nowhere alleged in the third amended complaint. On the issue of the merits, the court was abundantly correct in granting the dismissal on the intentional infliction count because there was no allegation in the four corners of the complaint that Kenneth McIntosh was in fact the target. That dismissal was in accord with this court's decision in the Habelow case.
Right. You agree that in the Williams case, there was no target and the acts were not in the presence of the parents?
Absolutely.
Do you think that decision was based on the fact that you're dealing with an individual who is dead, or do you think it was because otherwise you'd have a wrong with no remedy?
I think it's both, Your Honor. I've read the Williams case, and of course there are also exceptions in general impact rule cases for interference with a dead body. There's always been sort of a special exception carved out, and I think, like Your Honor said, first of all, the only victims of such a tort would have to be those who are alive and who would otherwise have no remedy. And because of the kind of specific nature of the claim, it's something that's kind of universally, abominable, and that's not what we have here. I think.
Well, let me ask you this. Let's change the fact in this case. Let's assume that the daughter was 6 months old and was the victim of a sexual battery, but not one that caused her physical harm, and due to her age, she could not appreciate any aspect of the offense. It seemed that there's an argument in that case that if the parent could not bring an action, there would be a wrong without a remedy.
Well, the parent would be bringing the action as the guardian of the child.
Right, but
and
for what?
Well, I think the assumption...
What would the damages be if the child can't comprehend it and there's no physical injury?
There may not be any damages in that instance, Your Honor.
So in that situation, should a parent be able to bring that action, or else you'd be back in the Williams case with a wrong with no remedy?
I think we're back in the Williams case, wrong with no remedy, at least insofar as those specific facts are concerned.
Yeah, and this court in Williams said that, we're not going to allow that. We're going to allow a remedy, correct?
With respect to the dead body cases, not in every case in which there is a wrong with no remedy.
Right. How about in this case where you don't have a 6-month-old, but you have a retarded, I think the term used was mildly retarded. Would that differ?
From the 6-month-old? Well, obviously, Ms. McIntosh is going to be prepared to present evidence that she was, in fact, raped. And by the way, that has not been established. There's been no criminal conviction. In fact, no criminal complaint brought against the other individual involved here. But assuming for the sake of argument she was, in fact, raped, she's going to have testimony that she has suffered as a result of it, both physically and emotionally, and so there is a remedy here, a clear remedy here, and in fact, as opposing counsel correctly notes, she's got a punitive damage claim pending.
And they actually asked for damages for her for mental anguish?
Yes.
Okay.
If the court has no further questions, I'll rely on my brief. Thank you.
Thank you.
If it pleases the court, Your Honor, this case was set for trial back in April and on date certain, but then it was changed this year. But I'm not sure if that makes a difference. But Your Honor, Pinky McIntosh, and we have alleged in the complaint at paragraph 27 that Pinky McIntosh suffered psychiatric care and treatment, including hospitalization. These losses are permanent, continuing, and the plaintiff will suffer these losses in the future. So we have alleged that she has permanent injuries, Your Honor, as a result of this here sexual battery. And as Your Honors know that the facts in a motion dismissed, the facts alleged in the complaint has to be accepted as true, and all inferences accepted toward in favor of the plaintiff.
Isn't the standard for the consortium claim permanent disability, not just permanent injury?
It is permanent disability, Your Honor, and we are providing evidence that she is totally permanently disabled. And that's why we said psychiatric care. She's been institutionalized quite often since this here happened. And Your Honor, we have a right, once we do general pleadings, to go ahead and enter evidence to support that. But also, Your Honor, when you have a motion to dismiss and you seek leave to amend, you can flush out additional facts. That's the purpose of amending, so that you can bring in whatever additional facts. That's the purpose of it. Your Honor, also, Mr. Burke has been convicted of a crime. You can go out to the New Jersey Attorney General site, and he is listed as a sexual predator, and those claims against that, assaults against that 13-year-old and 2 other minors are listed as under his sexual predator, and he's designated as that, Your Honor. Your Honor, I just went to the Strader case, Your Honor. I'm sorry, I misplaced that right now. But, Your Honor, as I said, it would be an anomaly that a parent whose child was put in position that they were, in essence, the hen in a coop and they brought in a fox. In this case, they brought in a sexual predator who they knew for money to get an extra $71 a day to this place. And as the Florida legislature has stated, they knew it was going to happen again. These sexual offenders and predators, they seem not to be able to happen.
I don't think anyone's disagreeing that if the facts are as you allege, there's a wrong. I think the question we're dealing with is what's the remedy and who has the remedy. So.
Yes, sir. Your Honor, I think as this court stated in the city of Manila, there has to be an arbitrary line. And in that case, they drew the arbitrary line as the parent, the spouse, the sibling, and the child. And, Your Honor, so in this case, we would ask the same, because there is no public policy to protect a sexual predator or to protect someone who willfully violates the law, and by limiting it to this intentional infliction. And lastly, Your Honor, there is another case for malicious infliction, where Mr. McIntosh did have a claim for loss of filial consortium. And then as parasitic damages, he can bring in his emotional claims. That's under a well-established rule of law also, Your Honor. And to deny him totally would not do justice in this state. Thank you so much, Your Honor.
Thank you, Counsel.